Well, hello there. Thanks for joining me. I am Dr. Jen, and this is My Life as a Landlord. Thanks for being here. I am so pleased you joined me and location-specific tenancy guidelines for Canadian Province of Quebec. In all of my location-specific episodes, I've included a number of hyperlinks and resources in the show notes to help you get started. Each of my location-specific podcasts is set up in the exact same way, answering the same four questions. One, what are the basics of the tenancy laws in Quebec? In this case, the Civil Code of Quebec, and there are other laws that feed into that, but in this case, that's it. Civil Code of Quebec. What are the nuances of this location, especially compared to the other locations that I've seen? What about some guidance on abandoned items left behind by a tenant in Quebec? And fourth, where to get help in your local area. If you're just getting started, where do you even start? Then at the very end of the episode, what I will do is I'll go through what I call my bingo card, which is the list of the most standard items I see in these locations all over the world. I'll review what's there, what's missing, even what's extra, and then I'll go into any other nuances that I see are missing, right? But I must tell you that there are more guiding documents. There is more local items that may be applicable to you. In fact, 5 minutes after I make this recording, there could be a change. There could be a change that I don't even know about. So you've got to do your own research for your own rentals in this specific area where your rentals are in Quebec. So please make sure you educate yourself beyond this, but this episode will get you started. I've got to give a plug today for today's sponsor, Aloha Capital Investments LLC. If you want to know more about real estate investing or what Michael and I are up to, check out alohajv.com. Okay, here we go. I'm going to screen share. So if you're watching this on YouTube at My Life as a Landlord, you will be able to follow along these guiding documents with me. If you're just listening, that's fine. You're going to hear me rattle off a bunch of information. I'm going to try my best not to just read from the screen. I'm just going to go through and pick out the highlights. But let's get started with screen sharing a bit. Let's see, where are we? Here we go. Okay, what you see on your screen is quebec.ca, and then in English, this is about housing and territory, and then renting, and this is talking about the rights and obligations of the leaseor and the leasee. And I didn't see a tenancy law type of thing. Now, the Civil Code of Quebec, there's actually 7 or 8 other laws that feed into it that set things like rent, deposits, all kinds of things. And it's actually very, very detailed. I'm really shocked at how detailed all of this is. So I'm going to go through as much as I possibly can. I'm going to hit my bingo card pieces and answer my 4 questions for this episode. But you need to really do your homework if you are a landlord or tenant in Quebec. Okay. So let's just go through this. Rights and obligations of the leaseor and leasee. You've got to see this. There's hyperlinks all over the place, like all over the place. So access to the dwelling and visiting rights. Both the landlord and the tenant have to abide by certain rules. You can't just have what's called abusive access, especially by the landlord. You can't, you've got to have a certain number of rules about access to the dwelling and visiting the premises. Like, for example, when the dwelling is for rent or because work needs to be done, for instance, and you've got to give proper notice as a landlord. You cannot abuse access. Discrimination when renting a dwelling. This is true no matter where you're renting, whether in Canada, in the States, it doesn't matter. Even in Australia, there's in Europe, you've got to make sure you're not discriminating at all. There's got a Charter of Human Rights and Freedoms in Quebec that prohibits the owner of a dwelling or a leaseor to treat leasees differently on basis of any personal characteristics. Pretty much name one and you can't have it. If you believe that you're a victim of discrimination or discriminatory harassment, you can file a complaint. That's pretty standard, regardless of where you are. Eviction. If you're going to evict well, see, this is interesting because they're using this word eviction. I would say ending tenancy because eviction implies that the tenant did something wrong. This is basically a no-cause eviction, meaning the tenant didn't do anything wrong. But if they're going to divide the dwelling, enlarge it, or substantially change its destination, then this is interesting. For a period of 3 years, starting June 6, 2024, a tenant cannot be evicted by a landlord who wishes to subdivide, expand, or change the use of the dwelling. Some exceptions may apply. There's been a 3-year hold, and so we're about 1 year into it. We're just over 1 year into it. So there's 2 more years where in Quebec, you can't just end a tenancy for changing the dwelling in some way. Can't do it. Repossession of a dwelling. This is if the unit has been foreclosed on. Tenants may stay in their dwelling as long as they want if they respect all the conditions of the lease, if they play by the rules, pay the rent, and enjoy quiet enjoyment. However, in certain situations, the landlord may repossess a dwelling, and if they do, they must notify the tenant in writing with the required time frame. There is the asterisk on this one: protection of seniors against repossession and dwelling and eviction. Um, so they in Quebec, this is really unique. Households where at least one person is age 65 or over can, in certain circumstances, benefit from preventing their landlord from repossessing the dwelling or evicting them. However, in certain situations, the protection is not applicable. You've really got to know your homework, and you've got to be not afraid to either research summary cases, which I have, you'll see here as we go through in one of the hyperlinks I've got, where you can search some case outcomes, case summaries. But you can also pick up the phone, call, or walk into one of the housing offices and just ask the question and figure out what you're going to do. Educate yourself on some of this stuff, because it's not all here. It's very detailed, but I guarantee you it's not all here. Excessive noise. So this is quiet enjoyment written all over it. A tenant has the right to peaceable enjoyment of the premises, and anyone that is disturbed by the excessive noise caused by another tenant can first address the situation with the other tenant in order to amicably resolve the situation while informing the landlord. But if the problem persists, the tenant can send formal notice to the landlord, including specific deadline for them to act. And if the situation is still not resolved, the tenant can ask a tribunal administrative du logement, tribunal administration of housing, to assert their rights. And so that's the group that will mediate and try to solve the complaints between tenants and landlords, right? And I'll get more into that. I have a couple of links that lead to that as well. Filing with the Tribunal Administrative du Logement is in, you've got another hyperlink. I'm not going to click it because it will go there. But in the event of the dispute, you want to make sure that you've got everything written down. Applications have to be filed and applications have to be submitted, and the other party must be notified properly, and then everyone will be summoned to a hearing. The Tribunal Administrative du Logement offers a conciliation service, which is basically a mediation, right, to help find a solution to solve their disputes. However, filing an application or filing an application with the tribunal is a requisite for an application. It's a prerequisite for an application for conciliation. They're going to make sure, if they can avoid you going to court because you can get a mediation and you can make an agreement out of court, they're going to want to do that, right? Of course, in Quebec, they're talking about heating problems. The leaseor is required to ensure proper functioning of a heating system. This is basic. This is an essential element. Major work. Before undertaking major work, such as renovating a bathroom or kitchen, landlord must give the tenant notice of a dwelling 10-day notice. When the work is completed, the tenant will pay the same rent for the duration of the lease. The landlord may not request an increase or change any other conditions of the lease except at time of renewal. So even if they renovate the kitchen, it doesn't matter. They still get to the tenant still pays the same rent. If the unit is sold, if there's a new owner that comes in, as soon as the sale of a residential rental building is finalized, the former or the new owner of the building must give the leasee written notice of the change of ownership. Lease conditions remain the same despite of the change in ownership, because the leases transfer. They transfer directly. So they must be respected in full. That makes sense. Obligations of joint tenants. If a joint tenant is a joint tenant, this is the definition of a joint tenant, is defined as someone who rents the same dwelling with one or more other tenants. Joint tenants who sign lease have obligations towards each other and towards the lessor. In principle, as soon as there is more than one tenant, each tenant has the obligation to pay their share of rent. However, if the lease includes a clause stipulating solidarity, one of the joint tenants can be sued for the full rent. So here's how we do this. That if we have, let's say we have roommates, we've had 2 or 3 roommates, we only want one deposit, one rent payment, and one main contact. We'll have all the contact information for everybody else, but we have the contact, one main contact for everyone. But if someone says, hey, I paid my rent, you can't evict me. No, that's not true. Everyone on the lease is acting as a group, right? So that's the same thing, is a joint tenant. That's what they're calling them in Quebec. Paying of rent is a principal obligation of the leasee. A leasee does not pay rent full on the agreed is in default as of the next day. No grace period. Under the law, if the parties do not make any particular arrangements regarding the payment of rent, it is up to the leaseor or the leaseor's mandatory to connect the rent at the leasee's home on the agreed date. So they don't make any notice about late payments. There is a prohibited practice. The leaseor, for instance, cannot demand post-dated checks or payment exceeding 1 month's rent. Right. Okay. Let's keep going with pets. We're almost through this part, and then I'll keep going with some of the other hyperlinks and resources. Landlords have the right to prohibit the presence of animals in a building. So this about pets. Now remember, a pet is an animal that does not have a job. This is a freeloading animal, right? A service animal has a job, which means it's not a pet. Okay, so this is under pets. Landlords have the right to prohibit the presence of animals in a building. There are exceptions, however. For example, the landlord cannot prevent a tenant from having an animal that helps them cope with a disability, which is a service animal. The lease or building rules generally mention whether it's allowed or prohibited to have an animal in the lodging. You cannot inhibit a service animal. Okay, right below this part, there is a summary of decisions regarding pets. Now, I'm going to go ahead and I'm going to jump to that one, which is here. And now it is a separate hyperlink in the show notes. So if you're interested in this, there is other summaries of decisions on here. Now, this is super helpful because what this is this is other cases that have had a dispute before you in Quebec and the outcomes. And they'll talk about exactly what it is. So in this case, the pets, they say the lessees are in breach of the lease and bylaws of the building because they own a dog while animals are prohibited. Summary of the application. The leaseor seeks resiliation of the lease. The outcome of this dispute was the administrative judge postpones the resiliation of the lease, and the lessees are ordered to dispose of their dogs within 60 days. Basically, they have to rehouse them. I mean, they knew the rules. So, and the reasons here, the clause prohibiting the presence of animals is legal. No tolerance on the part of the leaseor. Lack of specific and comprehensive medical evidence allowing lessee to keep their dogs for pet therapy purposes, meaning it's not a service animal. They can't prove it's a service animal. And it is inappropriate to distinguish the type of animal or its temperament, either a small dog or hound. And then it's got the full judgment that is a hyperlink that you can go, it's a PDF, and you can go right in and read the entire case rules. And there are others. So there was one that has a rabbit that was not allowed. This one has following the death of a tenant's dogs, the lessee adopted a new dog. Replacement of animals. So there's probably 7 or 8 summary in here. And of course, they've got a search engine at the very bottom of this page. They've got a search engine. Oh, it says it's in French only. Hopefully you read French, but you can go through this. This is actually very helpful. And pets is not the only topic. So assignment or sublease, cannabis is another topic, condition of the dwelling, conditions of the lease, conversion of a rental property into divided co-ownership, COVID-19, low rental housing, neighborhood disturbance. Then, of course, pets, that's the page this is on. Proceedings before the tribunal, administrative delodgement, termination and renewal of the lease, and use of dwelling for commercial purposes. All of these are case summaries and are in here, and I'm certain that there are more. So you want to make sure that you're looking at this. The next hyperlink that I had put in here was the Quebec Tribunal Administrative du Logement, so administration of housing. And this is their website. And if you just go to www.tal.gouv.qc.ca, and then this one's in English, there's also one in French, of course, you can go and there's some hyperlinks. This is right on the homepage. Processing status of your case, filing an application to the tribunal, calculation tool. This is fixing the rent increases, calculations, all kinds of stuff. And then it's talking about where you can find the nearest office. It's actually got a drop-down menu of where you are, depending on where you are. Let's say you're in Montreal. So if you go to Montreal, and then you can make an appointment online there. You can call us for an appointment. There's a bunch of different things that you can do. And then frequently asked questions. This is really interesting. So you can go through this. If you all frequently ask questions, these are great places to find some information. This was preparing for hearing. and then they've got some calculation stuff on here. Okay, let me go to the last bit here. This is about abandoned items. Now, I did a search about abandoned items in Quebec, and what popped up was this article done by a law firm in Quebec. This is from June of 2025, right? So this is relatively new. I take it with a grain of salt, but this is informational, so I'm not endorsing this law firm. But this is, what do you do with the items that are left behind by a tenant? So this is actually really helpful, and it's pretty standard that you want to confirm that the tenant has actually moved out, and you actually want to make sure that that you're doing everything you can to notify the tenant and say, hey, you've got, whether you know their family, their friends, where they work, whatever, or if they've either passed away, maybe they're incarcerated, maybe they sent you a text saying, get rid of all my stuff, something like that. But confirm that the tenant has actually moved out. You might try to contact the tenant, notify your intention to enter the unit with at least 24 hours notice, of course. And this article actually asks, if possible, include a neutral witness to accompany you to the unit to document the state of the premises. So it's not just the landlord or the property manager that shows up. If the unit shows no signs of active life and the rent is no longer being paid, right? It's no longer being paid, then you can presume the unit to have been abandoned. And they cite Article 1975 of the Civil Code of Quebec. Remains subject to interpretation of a tribunal administration, the TAL. So caution is advised. So you want to make sure you're checking that. And you can also search for the summary cases on this. The second thing you want to do once you confirm the unit has been abandoned, document the situation, detailed photos, videos of each room, items left behind, inventory if possible, capture both the general state of the unit and personal belongings, and honestly make it in writing. That's important. Number 3, create an inventory. Make a detailed inventory of the items on site, date, type, condition, location of each item. And it should be validated, signed by your witness. If you've got a third-party witness there, that's good. And then again, try to notify the tenant that you've got their items, right? So according to Article 1978 of the Civil Code of Quebec, the tenant is required upon departure to return the unit free of personal property. However, in this case, they've abandoned units. This obligation is not met. You must inform the tenant that the belongings were left behind and offer them an opportunity to recover, and offers a model notice of abandoned belongings for this purpose. I'm going to go ahead and I'm going to open up this hyperlink. Oh, it's exclusive to members only. Okay, fair enough. If you know the tenant's new address, you can send it through registered mail. If you do not have local contact information, you must publish a notice in the local newspaper where your building is located in the public notices section. And basically, you need to do everything you possibly can to get a hold of this tenant or the tenant's family or someone to say, look, we have your stuff. And this is for 90 days. You must provide a 90-day period that says that you have had the items for at least 90 days. After 90 days and they haven't claimed their items, the items are considered forgotten. The holder may dispose of it as they see fit after giving a notice to the same duration of the person who entrusted it. Yeah. So the 90-day period either begins on the date when the tenant receives the notice or the date the notice is published in the paper. Oh, that's a long time. So you've got to inventory it. You've got to then shift everything into storage. You've got to pay for storage and try to re-rent the unit, right? And you may have to do a bit of a renovation. Okay, and the next bit is you got to wait your 90 days and manage the cost. During that time, you're responsible for the belongings, must store them in a secure place at your own expense. If the tenant contacts you within that 90-day period, they may retrieve their items provided they reimburse you for reasonable storage fees and, if applicable, administrative costs. If they do not come forward, you have legal right to dispose of the items, whether through sale, donation, disposal. If you sell them, you can keep the proceeds to cover your costs, but you must return the balance to the tenant if they come forward later. This is really interesting. I think you might consider calling the tribunal, the TAL, what do they say, Tribunal Administration du Logement. Yeah, you would probably call them or talk to them. I would highly recommend that if this is the case for you, because it can get really sticky if you do this wrong. If you do this really wrong. Okay, let's keep going. I've jumped back to the rights and obligations of the leaseor and leasee. I got sidetracked on the summary of decisions, but that's okay. Okay, in Quebec, you have to use an RL31 slip to report information about leased dwellings. It allows lessees or sublessees to ask for solidarity tax credit on their income tax return. This is something typically done every January. The landlord of an eligible dwelling, and of course you'll see if you're watching this on YouTube, eligible dwelling is yet another hyperlink. Let's go to that. The landlord of an eligible dwelling must provide an RL31 slip to any person whom they signed a lease for which rent was paid or payable on the last day of the previous month. So in this one, it says payable December 31st, 2020. It might be 31st anyway. All right, let's go to eligible dwelling. So this is eligible dwelling for solidarity tax credit. And of course, we went to Revenue Quebec. So this is the tax provincial tax group for Quebec. And this is the definition of an eligible dwelling. So this is anything in here. I'm not going to read through this, but there's like 8 different versions of this, of what it is. But it's a dwelling that can be rented on its own, essential services, things like that. Okay, I'm not going to dwell on that. If you want to read what an eligible dwelling is, there's lots of hyperlinks through this. Unsanitary conditions. A leaseor cannot lease a dwelling that is not fit for habitation. That is to say, a dwelling that is in such a condition to be a serious danger to health or safety of its occupants or to the public. They must also ensure that any dwelling they're renting is fit for habitation for the duration of the lease. This is where the rent repair stuff comes in. The lessee must maintain it in good condition in regards to sanitary conditions, and there's various responsibilities for both the tenant and the landlord. Urgent and necessary repairs. This is information from the TAL. A lessee who finds a serious defect or breakage that affects their dwelling or building where they live must address the leaseor, the landlord, as soon as possible, whether the situation is urgent or not. It could, for instance, be a blocked sewer pipe or furnace breakdown during winter. Obviously, that's an emergency, like big time. If the leaseor cannot be reached or they neglect or refuse to do urgent and necessary repairs, the lessee can then carry out the repairs and engage expenses, but they must limit themselves to essential work and keep costs to a minimum. It's an emergency situation, right? And then, of course, the landlord then will have to reimburse the lessee for reasonable expenses they've incurred. That makes sense. Okay, so now they've also got additional obligations of the leaseor under the Civil Code of Quebec and the lessee under the Civil Code of Quebec. I'm just going to pop into one of these. So there is a bit of a list on each page here on what it is. So you've got to deliver the lease. Okay, so let's go through some of these because this is on my bingo card here. I do want to go through this. Main obligations of the leaseor: when the leased property is delivered to the lessee, on the agreed upon date, the leaseor must deliver the unit. You must deliver the unit in a clean, habitable condition. Main obligations of the leaseor during the lease: give peaceful enjoyment of the leased property, maintain the dwelling in good habitable condition, warrant that the property can be used for the purpose of which it was leased, to maintain the purpose of that property throughout the lease, make necessary repairs except those that are assumed by the lessees, respect the laws pertaining to safety, sanitation, maintenance, habitability of the dwelling, building, etc. Make sure that the number of occupants respect the normal conditions of comfort and sanitation, and not to change the form or destination of the dwelling. Okay, so that's that. Handicapped person, death of a lessor. I'm going to go through here. There's some other obligations, but I'm not going to go through all that. I'm just going to go through this. If a landlord dies, the death of a lessor does not terminate a lease. The building passes to the lessor's heirs. Thus, they become the owners of the building and cannot challenge the validity of a lease. In other words, the lease continues until the end of the term and may be renewed. Both the heirs as the new lessees, as the new lessors and the lessees, the tenants, must respect the rights and obligations resulting from the lease. There is a signed agreement between a tenant and landlord in Quebec, and this makes perfect sense. Even if the building or the unit is sold, the lease transfers with it. If the landlord dies, the lease is still in force, right? Also, payment of rent. In the event of the lessor's death, the lessee who is unsure of the identity of the person to whom he or she must pay the rent must apply for the TAL to be allowed to deposit his or her rent there until such identification is made. It makes sense. If the tenant is not sure what to do, then call the TAL. They will help you, and if anything, they can prove that the tenant continued to pay rent, and they'll be documented. And that's actually probably the best thing. Application must be made against the succession of the lessor and the served at the last lessor's last domicile. Interesting. Okay. So I'm going to go back to obligations of the lessee under the Civil Code. Let's go to that one. Okay, so there's a bunch. Um, yeah, so basically the tenant side of the main obligations, same as the landlord during the lease. Paying the rent, let's go into paying the rent. I'm looking at a late fee. When and where should the rent be paid? Who should the rent be paid to? Payment methods, can I pay with a regular check? Um, Importance of proof of payment. So non-payment of rent, rent not paid, rent paid more than 3 weeks late. Okay, so if the rent payments are more than 3 weeks late, the tribunal can order the leasee to pay the rent and can also have the lease terminated and evict the leasee. So it looks like that if you are grossly late with rent, that the tribunal can take action. Execution of the tribunal's decision, executing a decision. Now there are hyperlinks all through this. This is really interesting, and it can be a little confusing, actually. I'm just going to expand the deposit of rent part. Notice of deposit of rent. Oh, this is over here. It's the same one. Okay. Deposit procedure. Oh, this is if you're going to pay to the TAL. Okay, got it. Got it. Okay. Students. If the students are a leasee, how this works: assignment and subletting of the dwelling, reconciliation of the lease. Okay. Elders. This is important. Notice of a leasee's death. Notice of termination of a lease. These are all forms. In fact, let me just open the next one. These are all forms that are great because this is notice of the leasee's death. Notice to the address of the lease dwelling. I hereby notify you that this person passed away on here. I lived with the leasee, or I'm the liquidator or heir. And then confirmation of the receipt from a landlord. That's actually really helpful when you receive that. But you've also got notification of termination of the lease due to the tenant's admission to a residential or long-term care facility, and notice of a new lease, change of destination of a dwelling for seniors. Yeah, so then in here, this is all for seniors. This is actually really, really good, really helpful. Ending a lease, this is all specifically for seniors, so we got to be careful on how we do this. Signing a lease with the president. Yeah, this is including meals. This is like care. This is like a care home on how this all works. Yeah, you have to be, it's very sensitive when a person transitions to a care home, especially if they're breaking your lease. You've really got to know you've got to do your homework here. So big time, do your own research. Handicapped persons, there is a whole page on this. Notice of termination of a lease due to a disability. Maybe someone got hurt. That's happened to me, where I've had a tenant that got so hurt, they basically abandoned the unit because they couldn't come back. They got that hurt. This is talking about service animals. Okay, let's resume here. I had to stop for a second. Sorry about that. Okay, let's get to this one. I think we had already talked about death of a leasee. No, we didn't. We talked about the death of the landlord, but let's talk about death of a tenant. The death of a tenant does not terminate a lease. The lease continues till the end of its term and may be renewed in the name of one or all their heirs. Interesting. Okay. But the leaseor may not unilaterally terminate the lease and remove movable effects from the dwelling. Yeah, so just because a tenant dies does not mean the lease is over. The heirs are still responsible, and the lease continues. It actually keeps going. However, the heirs need to inform the landlord that they've died. The rights of the parties in the lease differ depending on whether or not the leasee lived with somebody at the time of their death. If nobody was living with them at the time of their death, then you could terminate the lease before the end of term. Basically, notice that you're breaking the lease. Non-renewal of the lease, preventing the lease from being renewed. Occupant was living. And then the liquidator is the charge in person of settling a succession. He or she may ensure that the assets of the succession are manned with the interest of the heirs. To do this, the liquidator must follow the steps, and you've got to consult the website, Government du Quebec. Yeah, interesting. I was hoping that we would find something a little more nuts and bolts, like security deposits and things like that. I did not find that. I'm just going to pop around and look in the Quebec joint tenancy lease, moving before the lease ends, protection of personal information, renewal of the lease, termination of the lease, inability to occupy the dwelling because of a handicap, spousal violence or sexual aggression. Yep. So we're starting to loop here. I still didn't see anything about a security deposit. That doesn't mean it's not there, but that's okay. All right, I'm going to keep screen sharing with you, but I am going to go through my bingo card as we go. Tenant application fee, didn't see anything about the tenant application fee. If you're interested in that, I highly suggest that you contact the TAL and find out about that. Grace period for late rent without penalty. The answer is no. It's pretty clear that the rent is due when it's due and it's late as of the next day. There was no discussion that I saw about a late fee, whether it was a percentage, a flat dollar, or a max amount. I also didn't see anything about a security deposit. Lease wording. Oh, you know what? Let's go in here. I'm going into the bingo card, but I saw somewhere that there is forms. Yeah, hang on a second. Let's go back to the hyperlinks because there is forms in here under the TAL. And I want to make sure. Where did I see the forms? Okay, so here we go. Models of a notices, model notices for leaseors, leasees. So here we go. This is all kinds of information. This is just notices, notice of major improvement, notice of rent increase and modification. Let's look at the rent increase one. So rent increase, you can only increase it by what Quebec can tell you, and you must do it with proper notice. Here's how you do it. You give notice 3 to 6 months before the end of the lease. Yep. Exceptions all apply. You've got to make sure. So you can increase the rent, but how much you can increase it by, and looks like you can only increase it once per year. It looks like. Yeah, this is interesting. Okay. Let's keep going. Offer to sell, notice of eviction for, you can't do this one, subdivision enlargement or change of destination of a dwelling. You can't do that one until 2027, June of 2027. Notice of rent increase, notice of repossession, notice of new leasee, notice to a leasee. Okay, max rent, last rent paid. Notice of modification. Okay. This one, model of notices for leasees, notice of termination of a lease. So it's got a whole bunch in here, modification of lease, dwelling sublet, other notices, notice of abandonment of a dwelling. Let's go into that one since we talk about abandonment. So this is this is if something happens and the tenant is giving notice to the landlord that the dwelling is no longer fit. I will be leaving the dwelling, or I left the dwelling, and basically they're out of there, right? Interesting. Notice of cessation of cohabitation, leasee's death, rent deposit, notice to repossession. What is this one? So this is the notices you can file with the TAL. And then I'm going to jump back into the bingo card so we can wrap up this episode. Notice of change address, hearing recording, translation of a decision unavailable. Okay, so there is quite a bit in here, and I did see forms in here somewhere. There is forms. Let's see. Where are we? Okay, I'm still looking for forms. And they are in here somewhere, but that's okay. I'm just going to leave it for now. So there are pre-made forms in here, but there is so much information and it kind of goes in a circle. It's not super user-friendly, but it looks like it's all there and there's plenty of places that you can search. So top right corner, there's a little magnifying glass. You can search there. But I still haven't seen anything about a security deposit. Leases, lease wording and details. There was no details that I saw. Is an emergency contact required in the event of tenant abandonment, incapacitation, death, or imprisonment? It's not required, but it's good best practice to do that, especially with our aging population. You want to make sure you have some emergency contacts. Pets and animals, it did talk about pets. In fact, we had summary of cases about pets, pet deposit, pet rent. Some of those questions, basically the summaries that we saw was about ending the tenancy because of an illegal pet in some way. And so, but pet deposits, again, I didn't see anything about a deposit. Delivery of signed lease required, no. Condition inspection required at move-in, not that I saw. Standard warning letters or wording, yes, there's quite a few forms that you can use, which is good. Are there required maintenance inspections? Not that I saw. How often can the rent be increased? It looks like once a year, but I would check. How much can the rent increase? Quebec will tell you how much it is, and that's standard pretty much across Canada. If you can increase the rent, they will very likely tell you how much that you can increase it by. Not every place is like that. Alberta is a question mark. You can increase it as much as you want. Nunavut, same thing, but not in Quebec. They will tell you. Renter's insurance, is it required or mentioned? No. Is abuse of access defined? No, they did talk about, I guess I will say yes. They did talk about proper notice and landlord, you have to have an actual reason to go in and you've got to have written notice. Landlord retaliation defined and or timing, meaning the tenants have done something that the landlord will perceive is harmful, meaning there was like they reported them to code enforcement, they joined a tenants union, something like that, and the landlord's trying to retaliate, saying they're trying to evict them, decrease their services, or increase their rent. And typically when landlord retaliation is defined, there is some kind of time frame and say within 6 months you cannot evict, raise rent, or decrease services. In this case, it's not even addressed. And so we haven't seen that in Quebec at all. Is the end of a fixed lease abrupt or does it automatically convert to periodic? I didn't see any conversions at all, so I'm not really sure. Condition inspection at move out, unsure. Return of deposit timing, didn't see anything about deposits at all. Sure, it's in there, but I don't know. Again, can you use the deposit as last month's rent? Yes or no? Did not see anything regarding a deposit, so I can't answer that. And then items, abandoned items, meaning the value, administrative inventory, the storage timing, and disposition instructions. There was a lot about abandoned items in there, so make sure that you are checking in. If you've got any questions, make sure you contact the TAL to help you figure this out. I'm stopping sharing so that I can wrap up this episode. Each of my location-specific podcasts is set up in the exact same way, answering the same 4 questions. What are the basics of that location? What are the nuances of that location? Helping you with guidance about abandoned items left behind by a tenant at that location, and then where to get help in your local area. Then I reviewed the bingo card for stand-up items I see most often in tenancy laws in different locations. This is the exact same format I use for every single one of these location-specific podcasts. So if you want to know another location, you already know the format. You know how I'm going to go through it. But again, this episode is not all inclusive. You can tell there was a lot of things that I didn't cover, didn't find, and stuff can change very quickly. So make sure you do your own homework. This episode will get you started. If you're listening to this podcast, chances are you're either new to real estate or you're new to the real estate in Quebec. Things you can do to help yourself are dig deep into these websites, into the hyperlinks, call the TAL, look at the summary of decisions that have come out. Make sure you educate yourself as much as you possibly can. But even better, get into the environments with other landlords in your local area. And I mean either in person via a meetup or join social media and jump into the conversations and say, hey, I'm a new landlord in Quebec, or I've got this issue, this question. Go where people are talking about this stuff and educate yourself. I hope you enjoyed today's show all about the Canadian province of Quebec. As a kind reminder, please, if you haven't already, subscribe and follow the show, My Life as a Landlord. Much appreciated. Today, I'm recording this episode in Desolation Sound, north of Vancouver, British Columbia. Why? Because real estate takes you places. Where do you want real estate to take you? Join me in the next episode live right now in the library, episode 169, all about the U.S. state of West Virginia. I'll see you there.